Evening, everyone, and welcome to the fourth installment of Operation Safe Spaces Family Law Seminar. For those of you who are just joining us, we do have a few new participants. My name is Robin Paris, and I am one of the project managers at Operation Safe Space, along with Dr. Marcia Hines, Dr. Yvonne Weeks, and Nathan Gibbons. We are excited to welcome back Sara Pierre, our Human Rights Advisor of McGill University, who is going to be continuing our overview of best practices in international family law. And again, we have a couple of quick housekeeping notes that we'd like to go through before we get started. Again, Sara will be doing this as an interactive presentation, and she will be soliciting you for questions and comments. And we also have Sara's sister, who has graciously agreed to share her survivor story after the break. Again, we pride ourselves on being a safe space for survivors, so we would ask that you make this a safe space for Sara's sister. If at any point during the presentation you have a question or would like to make a comment, feel free to use the reaction button and raise your hand or unmute your mic. All of these sessions are being recorded, and again, if you haven't already done so, please go ahead and complete the consent form and check us out on social media when you get a chance, IG or Facebook at oss.246. So without further ado, let's get started. Sara, over to you.
Great, thank you, Robin. It's nice to see everyone again and some new names as well. For those of you who weren't with us on Tuesday, my name is Sara Pierre, and I'm currently the Employment Equity Advisor at McGill. I'm also a graduate from the law school at McGill, and I have some interest and experience with women's rights and domestic violence and equality rights. And so today I brought up the agenda again. We had some really great discussions last time, and I'm hoping we can have those again. We'll start with a quick recap on what we went over on Tuesday. And next I'll be going over some of the best individual practices. Actually, before that, we'll be finishing off some examples that we didn't get to from different countries from Tuesday. And then afterwards, we'll have a break and we'll hear from Danielle. And then we'll finish off with a discussion on how we can move from simply legislation to actually implementing the legislation and changing the culture that we've all been discussing. So as a recap, we talked about how domestic violence is a human rights issue, a public health issue, and an economic and sustainability issue. We saw how international laws are not necessarily binding, but they still play an important role in setting international norms and best practices. We also went over the principle of due diligence, which gives states a positive duty to protect victims of domestic violence. We went over some best practices for states to tackle domestic violence, which includes recognizing it as a crime, creating mechanisms to investigate and punish perpetrators, offering resources and protection to victims, such as restraining orders, shelters, hotlines, legal assistance, and finally providing training for police, judges, social workers, and healthcare professionals. And lastly, social marketing campaigns to change norms and encourage women to report violence and seek help. And finally, we went over what domestic violence courts and units are, as well as the coordinated court model, and how they act as systemic strategies aimed at improving the efficiency of handling domestic violence cases. So I'll just start by going over some different examples from different countries. I'll start with the US and Canada. they're pretty similar in that they both prefer a heavy criminal response justice to domestic violence cases. So they go through our criminal system. There's a focus on the offender's criminal action and threat to society, as well as other potential victims. So this is different from some other states where we see, for example, Australia, Germany, and UK, they put a heavier emphasis on alternative intervention strategies, and it's more of a victim-centered approach. Sometimes this means, this is controversial in states like the US and Canada, where there is a heavy criminal justice response. Sometimes it means that there can be an arrest regardless of the victim or survivor's wishes. So, for example, sometimes, as we'll talk about later, it's not uncommon for domestic abuse survivors to recant or disclose something and then decide that they don't actually want to go through with a court process. And sometimes the court will decide to go ahead with it anyway because they know that they have the evidence, and since they know that the perpetrator was breaking the law, then they want to go through with it anyway. So that's a controversial point of view and perspective, and it's not shared by other countries which have progressive domestic violence intervention strategies. And finally, while a large majority of countries have adopted specialized laws on domestic violence, Canada instead includes aggravated penalties in the criminal law for violence against spouses and other family members. So in Canada, where I am, we don't actually have one law that says that it's illegal to practice domestic violence. We have certain targeted laws in different provinces, but instead we have a system where the different acts that would qualify as domestic violence are included as charges. So for example, sexual assault or stalking. And then when sentencing comes, one of the aggravating factors would be whether it was done in the context of a family. I want to show a quick news clip, which is talking about an incident that really, I would say it became a really big deal in all throughout Canada. It's about Justice Robin Camp, who made some very inappropriate and harmful comments during a case that he was presiding over. And I wanted to share with you just to show how, sometimes Canada is seen from other countries as a country which is very progressive, but, even in Canada, we still have the same we're still fighting against the same cultural norms of patriarchy and male dominance that all other countries are as well. But I also wanted to show the clip to show that there was something that came out of this. There were consequences for this specific judge. And very, very recently, we had this new bill C3, which accounts for training, which will be implemented for all new judges at a specific level. It's all new judges. It's all new federally appointed judges, and it calls that they have to agree to take continuing education on sexual assault law and surrounding this social context as well. So that's going back to what we were saying about cultural competence, training, how it needs to be ongoing and evolving. And the social context would also give them opportunities to explore what domestic violence looks like in the context of systemic racism and systemic discrimination. So I will pause here and share the clip.
The pressure on federal court Justice Robin Kemp built all day for comments he made as a lower court judge during a sexual assault trial. He ended up acquitting the young man involved and demanding the young woman explain her behavior. Well, in a rare move, a panel of fellow justices and the government agreed Kemp had to go. So as CTV's Glenn McGregor reports, he quit first.
The judgment against the judge was scathing. Justice Robin Kemp deemed no longer fit to serve, according to the Canadian Judicial Council, because of conduct manifestly and profoundly destructive, and his reliance on discredited myths and stereotypes about women and victim blaming. The council recommending Parliament remove him from the bench. Shortly after, the Justice Minister launched the procedure to do just that.
That the House agree with the Canadian Judicial Council's recommendation to remove Justice Robin Kemp from the Federal Court of Canada.
But within the hour, Kemp tendered his resignation in a letter expressing sincere apology to everyone hurt by comments he made in a 2014 sexual assault case in Alberta Provincial Court, where he remarked that young women want to have sex, particularly if they're drunk. Sex and pain sometimes go together, he said. That's not necessarily a bad thing. And asked why the complainant didn't keep her knees together. The woman in the case can't be identified because of a publication ban. Today, she welcomed Kemp's resignation.
I was feeling so unhopeful and pretty down and like not very hopeful about the justice system, but it has kind of turned around by this.
Kemp was later named to the federal court, one of dozens of judicial appointments made in the last year of the Conservative government. The case is not the only one to raise questions about judges' handling of sexual assaults. In Nova Scotia, Judge Gregory Lenihan this month acquitted a taxi driver accused of sexually assaulting a passenger so intoxicated that she passed out. Lenihan saying in his ruling that a drunk person can give consent.
The Conservatives have introduced legislation that would require better training for judges handling sexual assault cases. Today, the Justice Minister agreed that judges need to be properly trained to maintain public confidence in the courts. Kevin.
All right, Glenn, thank you.
So these cases that were talked about aren't necessarily domestic violence cases, but they're still cases of violence against women, and they all are fighting against the same cultural norms of how women should be treated in society. And so I think what's really interesting is that this judge was not able to get away. Well, in some sense he did, but at least, what he did was brought to light. And I think a big part of that is thanks to advocates and the media who put pressure on the government to change things like this. So we're going to continue and move along to looking at the example from the UK. And so the UK is considered a world leader after pressure from feminists, activists, advocates, and academics for decades. The pressure resulted in research, which is critical in terms of getting key stakeholders on board with changing domestic violence and how we intervene. And their research particularly led to some sophisticated risk assessment instruments, which I will show a couple of examples of. The UK is also considered a leader in developing multi-agency responses to domestic violence. So as we were talking about before, the UK does employ domestic violence courts. They have multi-agency risk assessment conferences, and they integrate healthcare programs with partner agencies, since we also spoke about how the healthcare is significantly impacted by domestic violence. One thing that I did find, however, is that due to there were recent legal aid cuts happening in the UK, they did make an exception for domestic violence cases. However, some argue that because of this exception, it is putting the burden on survivors to explain that they were and are victims of domestic abuse. And so there's that controversy that's happening right now. Now, in terms of risk assessment tools, I wanted to show you all a couple. So one of them is from New South Wales. It's called Domestic Violence Safety Assessment Tool. So this is a tool that can be used by both government and non-government agencies other than the police. And its use is, it's designed so that service providers can assess what the risk is of violence towards the client. So for example, you see here, part A, risk identification checklist, violence towards client. You have the risk factors in the column on the left. So for example, the first question is, has your partner ever threatened to harm or kill you? So we have yes, no, unknown. This is really interesting. There's a column for refuse to answer, which is quite common, depending on the level of trust and where the survivor is at with themselves. And the source of information, so can be used not only to between a lawyer and a client or an advocate and a client, but it can be used to get information from other people as well. The next section covers the relationship between the client and the partner. Is your partner jealous towards you or controlling of you? Here it incorporates texted, constantly harassed or texted or emailed you. Does your partner control your access to money? So going back to what we were saying a little bit earlier about financial abuse, which we'll be hearing about again from Danielle. The background of a partner, whether the partner is unemployed. And this is not to say, of course, it's not to stereotype a certain type of person, but I think it's more how individual factors relate to the systemic and cultural norms. So for example, if the partner is unemployed, and we know that usually domestic violence survivors are women in a patriarchal culture where men are supposed to be the breadwinners, it affects how a man might feel about being unemployed. This one's interesting too. Has your partner ever threatened or attempted suicide? That's something that people don't really think of as a type of abuse, but in certain situations it can be. There's a section for children and for sexual assault. And so at the end, you would tally up the numbers. If there's just one or more yes, then it's a threat. If there are 12 or more yes answers, it's a serious threat. At the end, the part B is professional judgment, which would be just filled out by the lawyer or advocate. The threat level, and then at the end, there's a section for the action required. So this is one example of the tool. Another tool that I found that is very popular right now internationally is the Ontario Domestic Assault Risk Assessment. And its purpose is a little bit different. It's more about predicting violence in heterosexual marriages or common law relationships. And it's about predicting the violence with your client, but also with other potential future partners as well. So again, we have a scoring system. A score of 0 says that 5% of such wife assaulters commit another assault against their partner, or in some cases, a future partner, that comes to the attention of the police within an average of about 5 years. And then you can go up to a score of 7 to 13, which leads up to a 70% chance. This one is just considering physical violence though. So that's one thing to keep in mind. So these are the type of questions that are asked. Failure on prior conditional release, bail, parole, probation, non-contact order, having more than one child altogether, having a biological child from a previous partner. So that's another example. On Tuesday, I told you that I would be sharing a couple of quotes from the reports from the Special Rapporteur on Violence Against Women, its causes and consequences. So one of the more recent ones from 2018 is from the Bahamas. And we see, I'll just read out the quote. Given the current stigmatization of homosexuality in Bahamian society, there is a concern that the discrimination they face could influence police attitudes, thereby having an effect on sexual assault investigations. The Task Force for Gender-Based Violence noted that crimes against lesbian, gay, bisexual, and transgender individuals, such as rape, sexual assault, and domestic violence, were among the most underreported and undocumented crimes. So this is just an example to show how we were talking about cultural competence and how it's important to know about the specific communities who are rendered more vulnerable. Another example that I took was from the Sudan. This report is from 2015. The Special Rapporteur was informed that, owing to the limited facilities for reporting violence and the lack of an effective response if such facilities are used, victims of domestic violence face further problems, including being encouraged by the police to seek reconciliation, which contributes to their re-victimization. Such factors contribute to the silencing and denial of the problem, and also to the denial of remedies. So I know this came up in our discussions on Tuesday, and I hope that we can continue having those discussions. It's a big question to face, how to change cultural norms around this, how to encourage and get training for the police force, since they are the first responders oftentimes. And I know this is common even in Canada sometimes, and I think I'll be speaking about that as well. And then the last country that I wanted to talk about was Australia. They're leading the way in domestic violence interventions. They've actually publicly recognized that domestic violence is a pandemic. And the rest of their interventions, I think, are pretty similar to the recent amendments in 2016 to the protection orders. You can correct me if I'm missing anything, anyone in the chat, but in this case, police can take out civil protection orders on behalf of the victim and sometimes can issue the order themselves. There is more of an emphasis on protective orders than arrest, and the orders will only become criminal if they are violated. One of the things that is halting the progress on domestic violence interventions in Australia is the fact that they are such a large country and they lack a national legal framework and cohesion among the states and territories, which I think is similar to Canada as well. So moving on to the next section, we've talked a lot about best practices at the institutional level and what countries have done around the world. I want to try and focus in more now on what are some best practices that are being used in the specific context of lawyers who have a client who is a survivor of domestic abuse. So the 5 next slides that I'll be focusing on will be about expertise and sensitivity that the lawyer needs. vertical case handling. I mentioned this before and I'll re-explain it again. Collaboration, support services for victims, how crucial this is. The specificities of intake when you are reading a new client and you perhaps don't know that they might be in a situation of domestic violence. And then finally, fighting against distracting litigation tactics. So for expertise and sensibility, the importance of building a relationship of safety and trust is absolutely crucial. And I know there are a few lawyers who are participating today who have had experiences with clients who are domestic abuse survivors. And I was wondering if any of you would like to share of your experience and how you were able to gain that trust and what that was like. Do we have any lawyers who specialize in this area? I think, Lani, I think you were speaking in previous conferences, previous workshops on having clients who have faced domestic violence. Do you have anything to add here?
I don't really have anything further to add other than what I'd said previously. I will say it is very difficult to get your clients to trust in the system. A lot of times they already feel as though the aggressor has more power and control and influence. And when things move in the way they typically move in the Barbadian justice system, which is very slowly and seeming to them being unfair, it's very difficult for you to build up confidence in yourself as an advocate and also in the system. I've had situations where we've had a client was basically attacked by her spouse and, taken her car keys, her house keys, everything taken away from her. And she was worried that her daughter would be taken away from her because she was a non-national. And right up until the day of court, the lawyer on the other side basically approached her and told her something that made her change everything. And she recanted everything that she said, and she didn't bother going forward with the application. So I then appeared as if I had forced her into the application, which was not the case. So it's not something that's easy to get any kind of, you can't really give any assurances to your clients, because how the framework is supposed to work is very rarely how it does work. A lot of times on very simple technicalities, and again, a lot of times I'm not actually there when the actual application is being made before the magistrate. So I don't actually see documentation until the person comes to me. And at that point, sometimes unless they had the presence of mind to have a copy of it, I don't have it. So oftentimes we have to make applications to amend the actual application for the protection order, and that causes all kinds of problems then as well too. So it's not really the best situation. When the client is visiting the police station, the police do not really help them in the actual preparation of the application for the order. It's just a form that they're told to fill out, and they don't always put in the essential information that's necessary in order to get the order granted. And so when that happens and you go now and the other side raises this as an issue, you can see it kind of starts falling apart, and it's nothing really that is anyone's fault except for the police officer or the person who was assisting the person when they were doing the application. They should have had some kind of knowledge as to what they needed to put in the application to assist the process to make sure that it doesn't have any technical defects.
Thank you, Lonnie. You raised a couple of really important things that I want to bring up again. So the idea of recantation, so that's very prevalent with victims of domestic abuse, wanting to end the abuse and get into a better situation, disclosing an incident that happened, but then there are a million reasons why they are more likely to say, you know what, never mind, I'm not going to go through with this anymore. Some of those reasons can include the victim's financial dependence on their partner, their abuser. There is a lot of psychological vulnerability. There's perceptions of an unsympathetic criminal justice response, which Lonnie was also talking about. You know, the victims see how many failed processes go through the courts. Sometimes it depends on the advocates. So that's why I'm stressing also it's really important for lawyers and advocates to have this kind of special training, expertise, and sensibility because of how different it is to have this kind of a client. Sometimes it has to do with the emotional attachment to the abuser. It can also come from pressure, family pressure, cultural pressure, religious pressure to remain with the abuser. There's a lot of shame and embarrassment. Sometimes if the victim does not have their papers, they might be afraid of being deported. There's a lot of feelings of guilt. So a lot of the times victims might feel that just recanting is actually the most safe option that they can take. So a lot of the job of the lawyer is to build that relationship, which can decrease the chances of recantation. Obviously, you can't, it's not 100%, you know, as we've seen, but that's one of the things that can help. And also, lawyers, you know, can't know everything, of course, so it's very beneficial to lean on the help of a special advocate who does know about, who is trauma informed and knows how to address the needs of the survivor. Cultural competency, we already spoke about that, being trauma informed, being just aware of the minimization and self-blame that survivors of domestic abuse also tend to have. For intake, this is when a lawyer or an advocate will be screening clients for family violence, knowing that the disclosure may not be immediate and the clients may not even recognize themselves that they are a victim or survivor of abuse. And then once the screening process is done, step 2 would be assessing the risk that the client faces. So doing those risk assessment forms that we have just seen. I'm going to show you an example of an intake checklist. This one is from Elizabeth Jolimont, and it's from the Department of Justice of Canada. So do any of these, I'll leave you a moment to read them, but do any of these particularly stick out to you? I'm seeing the comments here as well about protecting yourself as a lawyer, trying not to cross that line where you're trying to form a bond, which goes beyond the normal trust and confidence. Those are excellent points. So I think that lawyers take on a large amount of emotional labor when they have clients who are victims of domestic abuse. And I think that's where reliance on an advocate and collaboration really comes into effect and can help with that. One thing also that Lonnie mentioned that I'm seeing becoming more and more talked about is the threatened or actual kidnapping and harm to pets and property. Pets, I've seen this a lot, and I think Danielle can also speak to this later on. I'm seeing some calls to amend legislation to add pets as well. Of course, in a lot of jurisdictions, pets are deemed property, so they might be there anyway, but it seems to be a gap that we've seen. And then this section is on assessing the risk that the client faces. So we've already seen this with the risk assessment forms. Any questions about this section of intake? Okay, so moving on to vertical case handling. So domestic violence victims are unique in that they are often reluctant to disclose their abuse to anyone. And I've pulled a couple quotes from the National Domestic Violence Prosecution Best Practices Guide. This is a US-based document, and it's a really great resource. I've put the link right here. And so the first quote says, "To help victims regain trust in themselves and the justice system, it is imperative that the prosecution process offers consistency and continuity. It is important that victims feel they are being heard, and this may be effectuated by asking the victim to tell his or her story to one prosecutor, one investigator, and one advocate. Ensuring only one prosecutor takes the victim through a case from start to finish has the potential to show that victim, he or she does not have to resolve the problem alone, and that the justice system can be counted on to help keep him or her safe." So this is one of the strategies, just having one lawyer take care of the case from start to finish. Sometimes this isn't possible because of how the system is set up in one's country. But if it is possible, this is definitely the best practice. Collaboration. So we've already spoken a bit about this. It's helpful for both the client and the lawyer. If an advocate can address the basic non-legal needs of victims and their families, then they may be in a better place to disclose and cooperate. So we're really talking about clients who have been traumatized and may have been tortured for years and years by a partner whom they were probably in love with, maybe still are. So these things come with a lot of baggage. They take up a lot of room. So oftentimes victims may have neglected themselves for a while. They may be victims of financial abuse, so they won't have money, or they'll be having to take care of their children. So once all these non-legal basic needs are met, it's much more likely that the client is in a better place physically, emotionally, psychologically, to disclose and better be a better client, for lack of a better word. An advocate can teach the lawyer how to be sensitive to the domestic violence context. So, for example, all the things that we've been talking about, really, risk assessment, safety planning. So creating a safety plan if your client is still with their abusive partner, how they can leave. Resistance violence, which I believe Rashad and Leah spoke about last week. So when a victim is protecting themselves and defending themselves against their abuser. Cultural competency, PTSD, post-traumatic stress disorder, and other mental health challenges that might have arose from the trauma. Coping mechanisms, some of which may be unhealthy, some of which may be even criminal. So these are all things to keep tabs on. Recanting, delays in disclosure, and compelling victims to court, which is widely considered to be avoided as much as possible. And finally, I won't get too much into this because I do believe that there is another workshop directly on litigation abuse or paper abuse, or also known as procedural stalking. It has various terms. But this is one thing that lawyers and advocates definitely need to look out for if they have clients who are domestic abuse survivors. The distracting litigation tactics are employed by perpetrators who are dominant aggressors and can include excessive use of litigation to harass or the filing of multiple claims in various court systems. And there are other examples of litigation abuse as well. So, for example, if you're in a family law context, a parent who has never had a primary caregiver role or has had little regular involvement with the children suddenly applying for sole custody. Another example would be irrelevant or unsubstantiated claims. The abused spouse has engaged in infidelity. Frequent changes of counsel necessitating adjournments. It's not unusual for an abusive spouse to go through 3 or 4 lawyers. And again, they're doing this just so that they can have a sense of control. Again, we're talking about abuse as being about control and dominating. So using the legal process as their own tool to be able to continue to do this. And drawing out applications over a lengthy period and multiple adjournment requests without good cause. Do we have any questions before we take a break on anything that we discussed so far?
Hi, good evening. I don't have a question, I just have a comment. I found the intake form, the list in the intake form particularly helpful in terms of pointing out what we should look for. And just to say, there was one of them, I think it was when the person is overly protective, that stood out for me. And it stood out for me not from a legal perspective, but just experience I had with a friend many years ago, where her husband, if they went out, she could never face the other customers in a restaurant. She always had to back. He always had her in a corner, that kind of thing. And just so that as professionals and as that when we hear certain things, now it would set off an alarm. So that is why I thought that form was particularly helpful to make us aware of things that some of us may not be aware of. So that's it for me. Thanks.
Thank you, Sonia. I will put the link in the chat during the break. Any other comments or questions? All right. I will give us some time for break. Use this time to take care of yourselves. I know it's a very heavy subject, and so, feel free to do what you have to do to take care of yourself. And we will return and hear from my sister, Danielle, and her story. I hope that it can help destigmatize and demystify domestic violence. So let's say we come back at, let's do 6:28. All right. Okay, we're going to slowly return from our break, and we will stop recording for right now. So I'm going to go back to my slides. If you have anything else to say to Danielle, please do include it in the chat. So in our last little time together, I wanted to go over some of the strategies maybe that people have thought about for how we can move from simply having this legislation to actually implementing it. So some of the issues that we've come across in our time together are, we know that there's a cultural problem. We know that sometimes there's a lot of trouble with police inaction. We know that there's a lack of resources, where we know that sometimes it's really hard to juggle all the different systems involved, how they operate separately, and they all kind of have different priorities and goals. And we also know that underreporting is a very common issue. So we know that because sometimes abuse is normalized, like we heard from Danielle, you don't always know that you're being abused. I have an interactive questionnaire as an example that I will put in the chat. It's a tool used in Quebec for advocate. Well, it can be for anyone who's online. If they're curious about it, there are a set of questions and they'll say yes or no. And at the end, it will give them more of an idea of if their situation is dangerous or not. There's also little areas, tabs to say, emergency exit. So if you click on that, it'll lead you to a completely different page, just in case your abuser is checking to see what you're up to. It also deletes your history. So those kinds of things are important. We know that underreporting is also due to that intimacy between the perpetrator and victim. That's what makes it so different from other types of violence. As we also heard, there can be a lack of support, fear of retaliation or ostracism, not being believed, and avoiding emotional, financial, and personal risks. So looking at all of these issues, I wanted to share one story that has really stuck with me throughout the years. It's from when I was at the Institute for Human Rights and Development in Africa. In the Gambia, we had a conference with another NGO called Safe Hands for Girls. And the conference was a training for police, lawyers, and advocates on specifically female genital mutilation. And one of the lawyers at IHRDA made two really interesting comments. One of them, he said that, maybe FGM was once upon a time a part of our culture, but it is no longer. And so just that idea that cultures change and tradition and culture don't have to be the same thing. And then another thing that happened was since we were able to have the police and lawyers and advocates all in the same room, something really interesting happened. Someone from the police force said, I don't ever get cases, like, is this even happening? Like, nobody comes forward. And then an advocate said, yes, this is still happening. People come to me, but they don't want to tell police force because in that country, everyone knows each other. And the police take on an additional burden. If they bring forward this case, they might have social repercussions from their own family and friends. So that was really enlightening to see, so that at least now we know, okay, there's an issue here. Now we can start looking how to solve that. I think that knowledge of how to run effective educational campaigns is crucial. One great way is through the mass media, social media. I know OSS has an Instagram account that's really great. That's where people are, they're online. So things like that. Educational campaigns that are focused on bystander intervention are also seen as extremely important. So that's not necessarily targeting the perpetrator or the victim, but those who are friends and families of each. So knowing the signs of abuse and being able to step up and having the courage to intervene in that way. And then I've also put a link to the White Ribbon campaign. So this campaign, I think it sounds like it's a little bit like the Program for Peace that people were talking about in the chat on Tuesday. So that one is aimed at men, specifically boys and men, and trying to change that narrative. They have different campaigns of educational. There's also a pledge that boys and men can take to not engage in domestic violence or to speak up against it. So that White Ribbon campaign is very successful, and it originated in Ontario, I believe, but it's been popular all over in many different countries. And finally, I think that amended legislation that we've seen here in Barbados, I really do think that that's going to make a difference as well. As people are talking about it more and as things are changing, then that's how the rest of the culture can change as well. So I know it's 7:30, but I did promise that we would have a time to chat about strategies. So if anyone has any helpful tips or ideas about strategies as well, besides going to these types of workshops, yeah, you can feel free to say your piece now. You can chat or you can unmute yourself. One last thing I wanted to end with was this quote from Nelson Mandela. So I'll read it out. The 20th century will be remembered as a century marked by violence. It burdens us with its legacy of mass destruction, of violence inflicted on a scale never seen and never possible before in human history. Less visible, but even more widespread, is the legacy of day-to-day individual suffering. It is the pain of children who are abused by people who should protect them, women injured or humiliated by violent partners. This suffering is a legacy that reproduces itself as new generations learn from the violence of generations past, as victims learn from victimizers, and as the social conditions that nurture violence are allowed to continue. No country, no city, no community is immune, but neither are we powerless against it. I'll stop sharing here. If anyone has any additional comments, questions, please write them in the chat. I'll be sticking around for a couple more minutes. If not, I want to say thank you very much for your engagement and your participation. And I am excited for you for the rest of this series from OSS. Thank you so much for your work that you're doing.
Thank you so much, Sarah, and a special thank you to Danielle again for your bravery in sharing your story with us. That was very, very powerful. If there are any questions for either Sarah or Danielle, please feel free to either drop them in the chat or you can email me and I would be happy to pass those on. Next week, we will be taking an in-depth look at the Domestic Violence Protection Orders Act and what they really mean, and in terms of their current implementation today, as well as later in the week, we will be doing an in-depth look at the welfare checklist, which is currently being used in Trinidad and Tobago to determine custody and access and the best interests of the child, which is especially important in cases where domestic violence is prevalent in the dissolution of a relationship. Thank you guys so much again for being here. We look forward to seeing you next week. As always, please feel free to email us at operationsafespace.bb@gmail.com. Have a good night.